Good evening. I'm not going to make you wait 9 days for my response. This is pretty simple. 99% of everything that he brings up I've already addressed in these three videos. His content neutral Ward Rock v. Racism I addressed in content-based restrictions for dummies. I wasn't directing it at him, but it was brought up in relation to him. So you might want to check that out. You even say it has to be content neutral. Reed v. Town of Gilbert will explain it a little bit better. If they have to look at what you've taken a photograph of to determine whether or not that photograph is in violation of 18 U.S.C. 795, then that is specifically content-based. So you're looking at the wrong case there, buddy. You need a case that is content-based, and it has to address. So the test is, just to help you out, the test is if it's content-based, it has to be a compelling government interest. Now, typically, anything that is classified, designated, or marked as top secret, secret, or classified is going to be in the interest of national security and national defense, and therefore it is going to meet that compelling government interest. But then you have to have it be the least restrictive alternative. And the easiest way to keep people from filming the walls of your base, if those are in fact classified, top secret, or secret, is to erect a new wall in front of them. If you're wondering why I'm not addressing his classified, marked, or designated argument, I addressed it in one of these already. I mean, I have literally addressed every argument he's made with very few exceptions. I do want to point out that he does talk about the canons of statutory construction, but he never actually applies them. He talks about them, and then he just shifts off to, well, these other cases, they have a different, it's different. Oh, in Appel v. United States, look, the Supreme Court uses it different. Well, this is a definition for this particular chapter. This chapter is 169 of 10 USC chapter 169. I mean, it has nothing to do with 18 USC 795. Appel has nothing to do with 18 USC 795. And 18 USC 1382 is what Appel is dealing with. And this highlighted area is the ... This is the ellipses. This is just a shorthand way of laying out where 18 USC 1382 applies. It's just shorthand. And Appel is very much distinguishable from Grace. Grace dealt with sidewalks that are indistinguishable from other sidewalks. A Grace sidewalk, there's nothing to distinguish when you're entering a sidewalk that is on Supreme Court property, since it looks like every other sidewalk that runs along the side of a street. However, in Appel, you can definitely tell when you were entering the designated public forum. There is a green line on the pavement, a temporary fence. It's also bordered by Highway 1 and Lompoc-Casmilla Road. And there is a public advisory that explains what you can do and how you can do it on there. It's in the middle of a military base. This is completely different than US v. Grace. Yes, it is more recent, but it's an entirely different topic. So you just didn't understand what you were talking about. And I'm not trying to be a dick about it. This stuff is hard. And if you go all the way back to my earliest stuff, I didn't understand it very well either. And it's just through beating my head against this that it starts to make sense. I've been working on an ERISA case, and ERISA is the same way. Nothing makes sense, but the more you beat your head against it, the more it starts to make sense. I don't know why I brought up the ERISA case, but it's very frustrating. It's a lot more frustrating than the First Amendment. Anyway, so that's Appel. That was easy. He also brings up Zhao Qin Li. I don't know how to say it. He says it different. It would be really helpful, Mr. Bacon, if you would put links in your description, because you say it as, it comes up in here as XIAOJIANLI, 3 words. and it's two words and it's not spelled the same. I mean, I understand it, but that's why links would be helpful. It took me forever to figure this out. If you're wondering why it's 7:30 when I'm recording this, it took me forever to find this. So what the court documents show, according to the court record, he was apprehended after illegally entering a base. At the time of his arrest, he was observed taking photographs of the base. Ooh, what's this? And associated military hardware. I wonder what this associated military hardware is. I don't know, but I would presume that this military hardware might be something that is along the lines of confidential, secret, or top secret. I don't know, but that is something that you don't address. You say that he was convicted, and you specifically use the word convicted of filming a base. And if the base is restricted, then obviously filming a restricted base makes you in violation of 18 U.S.C. 795. But there is this pesky little associated military hardware. And another thing that I'm going to quibble with is that he pled guilty to it. He pled guilty to it. He wasn't convicted. The court didn't go over it. The court just accepted his plea. Now, pleading to this might make sense, especially if you might be facing something like this, where if you are taking a photograph with the intent to deliver it or communicate it to a foreign government, you could be facing death. Shall be punished by death or imprisonment for any term of years or for life. Now, in exchange for pleading to 795, he got 12 months and another year of 12 months in prison to be followed by 1 year of supervised release. That's a hell of a break. I mean, I don't know how he got the year of supervised release, but he's in prison for not more than 1 year or both. I don't know how I got the year of supervised release, but there you go. He got the 1 year in prison. I would swap a guaranteed 1 year in prison for the potential of death or life in prison. That's a no-brainer. So much like agreeing to a settlement, pleading guilty doesn't necessarily mean that you're guilty. Now, it is a strong indicator. I will grant you that. But there are people who plead guilty, especially if you can swap something like a potential death sentence for a year in prison. I mean, do you really want to gamble? I'm just saying. So this is not a smoking gun. This is a testament that you can be convicted, or that you can plead guilty. Essentially, you can plead guilty to 18 U.S.C. 795. Now, I'm not saying that 18 U.S.C. 795 only relates to information. It does relate to installations and equipment that require the protection against the dissemination of the information. That's why you can't photograph it. But he seems to make some argument that I'm thinking that it doesn't apply to physical locations, and it does. Installations to me implies a location, because this thing has to be located within, this location has to be located within something. Now, why he circles within, why he doesn't address within, I don't know. I'm not a mind reader. But according to the canons of statutory construction, he would actually have to deal with it, and he didn't deal with it. But it has to be located within. Installations have to be located within any of these things. Typically a base or a commercial establishment that develops or manufactures classified military, naval, arms, munitions, equipment, blah, blah, blah. So, but it has to be located within these things. And again, the canons of statutory construction make it seem odd and redundant if you say installations has to be located within an installation, or a base has to be located within a base. It doesn't make sense. You're ignoring it. You're ignoring the words on the page, just like Blue Bacon ignored the words on the page, and he skipped right by them because he knows it doesn't work. Try not to make this too long. I don't know what all I've covered, but again, these 4 videos will destroy everything that he said. This is irrelevant. The Army regs are irrelevant. They They don't, how the Army applies 18 U.S.C. 795 and Executive Order 10104 doesn't mean anything. The U.S. District Attorney has a whole bunch of different ideas on how these statutes should be interpreted. The Attorney General has ideas on how these statutes should be interpreted. The legislative branches have ideas on how these statutes should be interpreted, but it's what the court says that matter. And the court looks to what the legislative branch intended in the case of a statute or what the president intended in the case of an executive order. They don't look for Army regulations. I'm sorry, they just don't. You might think I'm just waving my hand and dismissing it, and I am, because it is literally not relevant. And the way it's defined in other sections, in other code sections, is literally not relevant. This statute, 18 U.S.C. 795, has to be read as internally consistent. And you can't do that by redefining installation to mean a base or a base to mean an installation. It no longer makes sense. Executive Order 10104 no longer makes sense if you redefine installation to base and base to installation. It no longer makes sense. And the statute is no longer constitutional if the walls of a military base, which have been broadly disseminated, because remember, this is to prevent the general dissemination of information, but if the walls of the military base have been broadly disseminated, and if the restriction against filming the walls of the base is content-based, because it's if you're filming a vital military naval installation, that's content, right? You have to look at the content of the photo. It's not just taking photos that's illegal, it's taking photos of vital military and naval installations and equipment that's illegal. It's content-based. So all of a sudden, it becomes unconstitutional. And Ward v. Rocky against racism doesn't help you at all. Anyway, I hope that helps. I mean, I know you're not going to believe me. I know you've got your head set on this one to go the other direction, but I think you're wrong. And I want to caution you. I am not accusing you of being a sovereign citizen, but one of the tactics sovereign citizens use is they find definitions in irrelevant code sections that don't apply to what they're talking about, and they use those definitions to try to redefine other terms. Driving is a big example of that. They take the U.S. code that relates to commercial drivers, and they try to make that apply to drivers in general, and it doesn't work. So I just caution you on that, sir. Thanks for watching. Have a great evening.